the sensitivity of the matter, and let me read out the judgment. It says, we have examined the facts and reports of the ASI as well as the principle that archaeology is a science. We rely on ASI's findings. ASI has full control over supervision and the authority to undertake conservation. This is what the High Court has said, and the court also stated that this is clear that this is a protected structure. Muslim side may file an application for land for mosque. We have considered the archaeological and historical facts, the notifications issued by the ASI and the survey reports. This is what the High Court has said. And furthermore, based on the statutory provisions of ASI Act as well as the precedent established in the Ayodhya case, and keeping in view the nature, the court can safely rely upon the findings of such multidisciplinary studies conducted by the ASI and upon the fundamental rights enshrined under Article 25 and 26 of the Constitution of India. This is what the High Court has said in its order. It's a big win for the Hindu side, because now the court has recognized it to be the temple of Goddess Vagdevi. We also have reactions coming in. Let's listen in.
देखिए आज भोजशाला के केस में माननीय देखिए आज आराम से थोड़ा सा शांति रखिए। देखिए आज भोजशाला के केस में ऑनरेबल इंदौर हाई कोर्ट का बहुत ही ऐतिहासिक फैसला आया है, जिसमें ऑनरेबल इंदौर हाई कोर्ट ने जो एएसआई का 7 अप्रैल 2003 का ऑर्डर है उसको पार्शियली क्वैश किया है और हिंदू समाज के लोगों को वहां पे पूजा पाठ का अधिकार दिया है। कोर्ट ने भोजशाला कॉम्प्लेक्स को राजा भोज का माना है, एक सरस्वती स्कूल माना है लर्निंग का। साथ ही साथ इसमें सबसे महत्वपूर्ण बात यह है कि भोजशाला के केस में जो हमारी मांग थी कि वहां से लंदन के म्यूजियम से मूर्ति वापस लाई जाए, कोर्ट ने कहा है कि सरकार इस रिप्रेजेंटेशन को कंसिडर करे। और साथ ही साथ कोर्ट ने यह भी कहा है कि जो मुस्लिम पक्ष हैं वो सरकार को रिप्रेजेंटेशन दे सकते हैं, जो रिस्पोंडेंट नंबर 8 है मौला कमालुद्दीन की तरफ से, और उनको अल्टरनेट लैंड देने के लिए सरकार उस पर विचार करे। पर सबसे महत्वपूर्ण बात यह है कि कोर्ट ने यहाँ पे हमें पूजा पाठ का अधिकार दिया है। मैनेजमेंट के लिए सरकार को कहा है कि वो इसके मैनेजमेंट के लिए चीजें देखे, और जो एएसआई का ऑर्डर था 7 अप्रैल 2003 का, जो यहाँ पे नमाज की अनुमति देता था, उसको कोर्ट ने सिरे से खारिज कर दिया है। अब वहाँ पे सिर्फ पूजा होगी, उस पूरे परिसर का जो स्वरूप है वो एक हिंदू मंदिर।
We also have Sanjay Chadha, advocate Supreme Court, joining us live on this broadcast. A very good afternoon to you, Mr. Chadha. How do you look at the court's order in this case? Your first response.
Well, still the full order is to be seen, but preliminary, if you see the preliminary few very important aspects like the quashing of the AIC archaeological surveys order restraining any other activity other than the rituals which were being performed earlier is now quashed. That order is no more there, and with that another permission as far as the prayers, Hindu prayers are concerned, that permission is granted. The court has also relied upon various documents which have been produced, which in substance, as per the court, are proving that it was that the entire structure was a temple and was a temple of goddesses Saraswati, and it was basically it was in not only in temple but also a mandir for shiksha, means thereby there the education used to be imparted there. It was established before the court by various authorities which were there, through which they have substantiated it, and the court has accepted that. Court has also granted permission for the basically a ritual which has to be performed there, the puja which is to be performed by the Hindus. Earlier that was restrained, and earlier there was the ASI has ordered that no such performance can be done. So that is what one aspect is, and the other aspect, when we'll read it further thoroughly, we'll be able to gauge it more proper. But one aspect, as
So
we have
reportedly
seen,
invoked the Ayodhya precedent. So how, important is this reference legally in this case as well as future such cases?
look, one thing is there, as invoked Ayodhya's precedent. Yes, that is a precedent which is established precedent. It has not been overruled by anybody. So the precedent primarily, as it looks, use of Article 142 was done at that point of time, where the Supreme Court, under its own power, has asked the Muslim Muslim petitioner to move the site and ask the government to give a location for about away from the temple site, for 5-acre land was given in that. So that precedent they have tried to follow, wherein they have respectfully, the court has asked the the government to, in case any such demand comes forward by the Muslim Pakshkar, then in that case the government should consider that, because the peace, harmony, that is the foremost thing which has to be accepted, which has to be adopted, accepted, and we have to live together in this country. So that's what
They become a template
is.
for other pending cases as far as religious structures are concerned.
I think it is not that straight away. We cannot conclude that, because still, if we go, there is a case which is pending before the Honorable Supreme Court, where the act passed in 1991, Places of Worship Act, which is still under scrutiny. Let us see what is, first of all, we have to see, if we talk about the rest of the places, if we talk about Mathura, if we talk about Kashi, and many other temples which where there is a dispute going on, temples or mosque, whatever you call it. So certainly one has to look into it from that angle. Whence that act is there, whether any interference can be made. So that is other point which is now once again in the light, and the Supreme Court has to decide on it.
And as far as the Muslim side or the mosque side is concerned, what are the options before them? Now, what we understand is that they are seeking a land for a mosque, but do they have any grounds to approach the Supreme Court against this verdict?
Of course, they have all grounds to go to the Supreme Court or the higher pedestal in the same court, because if they are able to prove the things which are erroneous in this judgment, if they are able to produce such things, the error in the current judgment, error which is apparent on the record, has to be, if they are challenging it, these are the grounds under which they can very well challenge it. If there is an error of law, error of fact, error of any nature is there in this order, then certainly the other side has the right to challenge it. And in case they challenge, it might also happen that at the first instance, the court might stay the order, the higher court might stay the order. But all depends upon what are the preliminary grounds which the Muslim Pakshkar brings before.
And so the court has also spoken about Articles 25 and 26. So when do, fundamental rights come into the picture in such sensitive cases, and what does this mean?
Well, as far as the fundamental rights are concerned, fundamental rights are rights which are the paramount rights given to each citizen of this country. So, as far as your question is, that when these fundamental rights come into force, they are always there. Even if I am disturbing your fundamental right, I am encroaching upon your fundamental right, you can very well go and file a writ against the state that it is here the fundamental right has been encroached.
So the judgment also says that the structure is protected under the ASI Act. So what powers does the Archaeological Survey of India get going forward from this case to more such cases in the future?
Well, it is a little, I'll now elaborate on this. Now, what happens is there is an Archaeological Survey of India Act is there, which says that any monument, any building which is above 100 years of age and which is of historical importance, that will come and which will and that will be taken care by Archaeological Survey of India. And in such cases, all the activities, religious activities, etc., can only be performed with the permission of Archaeological Survey. So that is what, even we see that this building falls within the Archaeological Survey of India's domain. So with the permission, if the case pertains to only this particular fact, that this particular building will remain within the Archaeological Survey of India's domain, number one. Number two, the order passed by Archaeological Survey of India restraining and not allowing the...
इसके खिलाफ हम सुप्रीम कोर्ट में अपील करेंगे। वकास सादिक शहर का जिला। फैसले के बहुत सारे पहलू रहते हैं। अगर हमारे खिलाफ और हमारे आर्गुमेंट के खिलाफ आया है तो माननीय हाई कोर्ट का सम्मान करते हुए सुप्रीम कोर्ट जाएंगे। बिल्कुल। यहाँ इधर साइड से आ जाओ, साइड से आ जाओ, आगे साइड से।
Well, Mr. Sanjay Chadha, you just heard the Muslim side there, and we predicted it right. They're going to approach the Supreme Court. So what are the legal options before them, and what are the, constitutional questions that will be asked?
2-3 very major things which are there. One, whether archaeological... First of all, one should be very, very aware of this, that there cannot be any change in this site. It is not that this site is now handed over to any Hindu Pakshkar or anybody else. Only and only one order which was existing, passed by Archaeological Survey of India, that at this place, on specific days, namaz used to be performed. That order is quashed, number one. Number two, going into the history of the documents produced by Archaeological Survey itself and many other documents, the court has said that this substantiates beyond doubt that this was a Bhojshala, a temple or a Vidya Mandir made by Raja Bhoj in honor of goddesses Saraswati. So this is what they have accepted. Now, what I feel, it is this building will remain the same. The control of the building will remain the same. So the challenge before is which the Muslim Pakshkar are going to go for is only and only the order which was passed by ASI, wherein they had permitted the Muslim Pakshkars to perform namaz and other religious activities for specific times, whether it was weekly.
And sir, the court has accepted ASI's findings, but the Muslim side isn't willing to accept these findings. And unfortunately, Mr. Sanjay Chadha, we've run out of time, but the road ahead is very clear. The Muslim side has made it crystal clear that they do not want to appeal for a land. Instead, they will land in Delhi to approach the Supreme Court. With that, it's a wrap on this edition of the Bulletin. Thank you for watching.
This is India's #1 news network, and you're watching News 9. English news as it should be.
The wait is over. After a massive response from corporate India, the stage is now set for India's biggest corporate badminton championship. Presented by TV9 Network. The biggest names are ready to battle it out on court. smashes that stun, rallies that thrill, and corporate warriors giving it everything on court. From 15th to 17th May 2026, witness the biggest corporate championship unfold live at the iconic Pulela Gopichand Badminton Academy, Hyderabad. The rivalry, the team spirit, one championship, one ultimate battle. Catch all the action only on TV9 Network.
Associate sponsor KL deemed to be university.
New India's new choice for gas. Go Gas. Generali Central Life Insurance, your lifetime partner. Orzil for faster hydration.
Special partners Campa Sure, Shukar hai, Sure hai. JK Max Paints. ChatGPT helps you get answers and find inspiration. Mana VVIT University. Absolute discipline and absolute education. Tridasa Rise, where life shines. Venue partner Pulela Gopichand Badminton Academy.
This is India's #1 news network, and you're watching News9, English news as it should be.
Viewers, the BRICS foreign ministers meet has thrown up a major geopolitical talking point, and it directly concerns India's rising global role and acceptance as well as stature. Because Russian Foreign Minister Sergei Lavrov has suggested that India could play a very important role in easing tensions between the US and Iran amid the ongoing Hormuz and West Asia crisis. Lavrov said Pakistan is currently helping facilitate dialogue between Washington and Tehran, but if a long-term and a credible mediator is required, India could emerge as a serious option because of its diplomatic experience and also balanced ties with all sides that are involved. Let's listen in.
You can see that Pakistan is helping establish dialogue between Iran and the United States to resolve the urgent problems, to resolve the existing crisis. And if we speak long-term, mediator between Iran and its Arab friends, well, this role could be played by India, considering its vast diplomatic experience and authority and clout.
Viewers, India has been maintaining strategic neutrality, and now Sergei Lavrov suggests that India must step in as far as the mediation is concerned. And the remarks come at a very, very crucial time with tensions continuing to simmer in West Asia, concerns over oil supply chains growing, and the world is watching the strategic importance of the Strait of Hormuz. Lavrov also underlined that BRICS as a grouping cannot officially mediate the crisis, but stressed that India remains uniquely positioned because it maintains relations with Iran, the Gulf countries, Russia and the West simultaneously. Importantly, Lavrov also confirmed that discussions were held on continuing Russian oil supplies to India, with trade increasingly being conducted through local currencies, the rupee and the ruble, a sign of possible change in the global economic order ahead of the BRICS summit in India later this year in September.